Hello, this is David Sofer. This is part 2 of Tierney, Sofer versus Chase. In my last video, I was explaining how I had sued J.P. Morgan Chase in Superior Court in San Diego. What I would like to add is that on the very first hearing, I actually appeared in court, and when I did, the judge ruled against me, and he would not even allow me to make my oral argument. You can ask any of your teachers, they will all tell you that your First Amendment right to free speech is protected the most at your own hearing in a public courtroom. So when a judge who has taken an oath to uphold and defend the Constitution deprives you of your right to free speech at your own hearing in a public courtroom, that is the end game. The bailiff told me if I did not leave the courtroom, she would call the sheriff, and when I simply tried to address the judge, he turned away from me, wouldn't even look at me, and the bailiff called the sheriff. So after that, I was attending all my hearings by teleconference, using court call, and when I would call in for the hearings, the judge continually deprived me of my right to free speech, except on a couple of occasions when, I don't know, maybe he wasn't concerned about who was in the courtroom, but on most occasions, he wouldn't even give me an opportunity to make my oral argument. He would just end the hearing and disconnect the call before I even had a chance to even say anything. On other occasions, he actually disconnected the call right in the middle of me speaking because I was embarrassing him. I was exposing him for the fraud he committed and the fact that the clerks of the court had rubber-stamped documents to dismiss the case against me without there even being a hearing, and then remove them from the case file, which is a felony, and I was exposing all this. So my right to free speech was continually deprived, and as I explained before, I contacted every civil rights attorney from San Diego to Los Angeles and beyond, and I contacted the Department of Justice. I sent them all the proof. I contacted the ACLU. They wouldn't do anything. Filed complaints with the State Bar and the Judicial Commission. They denied that anyone did anything wrong. And as I explained, I contacted the DA, but they're currently covering up for another case I'm involved in. Internal Affairs wouldn't do anything. And as I've explained, the dirty little secret they don't want you to know is the police, the prosecutors, lawyers, and judges all cover up for each other. That way they can all get away with whatever they want. They don't normally take legal action against each other whenever they can avoid it, and they cover up for each other. And they have to, because otherwise they could lose their jobs, and they have. So if you Google Sofer versus Chase and click on the first link that comes up for ChaseSucks.com, you'll find all the documents to prove everything I'm telling you. So I have to ask you, if no one will defend your rights, if your rights are violated, if you're deprived of your rights, and no one will do anything to defend your rights, if you've contacted everyone in the media, and no one will do anything, do you really have any rights? I don't think so. I really don't. I think this is tyranny. I really, really do. And I want to explain something to you about our judicial system. When they tell you that there has to be plea bargains because they can't take every case to trial, they're lying to you. Because think about it. If there were no plea bargains in the first place, it would give people an incentive to plead guilty right at their arraignment. And then they'd have an opportunity to tell the judge why they did what they did. And the judge would have an incentive to give them a lighter sentence. Otherwise, their case is going to trial. And if a jury finds them guilty, the judge is probably going to give them the maximum sentence. So unless it's, a capital crime, unless you're talking about a murder or something like that, then there's no reason why the judge wouldn't be able to give them a lighter sentence. There's no reason why there has to be, why the case would have to go to trial. People could plead guilty right at their arraignment, and if they didn't, they'd go to trial, and that would be it. But instead, it's the opposite. It's the opposite of the way that it should be. Instead, people all plead not guilty because there's no reason for them to plead guilty, and then the prosecutors have to prosecute people for, I don't know, a year or whatever. I was prosecuted for a year before I was given a plea bargain. And then when they offer you a plea bargain that's so good you can't turn it down, it's just not worth it to spend the money on going to trial. But think about all the resources and the time and the money, the taxpayer dollars that would be saved if they didn't have to prosecute these cases because there were no plea bargains and people would actually plead guilty at their arraignment because they know if they didn't, they were going to trial. So it's really the opposite. And in fact, the police will arrest whoever they want and the prosecutors will charge whoever they want because they know how difficult it is for people to prepare a case for trial. That's really what you have to do. You have to prepare your case for trial. You have to prepare your defense. Otherwise, you could wind up looking guilty if you don't have any defense, right? And it costs a lot of money to do that. And guess what? The defense attorneys don't really have any incentive to take your case to trial because if you don't have the money, they're not going to pay for it. And if they can get you to plead guilty, even when they could otherwise, get the charges dropped, like if your rights have been violated, like mine were, when the police broke down my door and wouldn't show me a warrant, if the lawyers could get the case dropped, the charges dropped, but they don't, if they get you to plead guilty, that makes the prosecutors very happy. And then that way, when these lawyers have a client who's in big trouble and doesn't want to go to trial because he knows he's guilty and he has no defense, but if he has a lot of money, he can pay his lawyer a whole lot of money to get him a good plea bargain, and his lawyer can do it in exchange for all the people they sell out. And the prosecutors will give them a good deal because of all the people they sell out. That's how it works. So the system is totally tyrannical. And the reason for the plea bargains is so the government can convict people without having to prove they're guilty. Because they can just make it so expensive for you that you run out of money before you can get your case to trial. And the defense attorneys will not represent you if you can't pay them anymore. Then you'll be stuck representing yourself. And they won't represent you if you demand a speedy trial because they will tell you they need time to prepare your case for trial. So you're essentially coerced into a plea bargain, and this is what happens to whistleblowers, like a man named Tom Drake who worked for the NSA. That's why Edward Snowden did what he did, because he saw what happened to Tom Drake when he reported people in our government for 9/11. He went to the Inspector General, and then he got wrongfully and maliciously prosecuted for espionage. And this has happened to people in the CIA, the NSA, the military, and even our own media. So that's the reason for the plea bargains, so the government can essentially coerce people and convict them without having to prove that they're guilty. So something needs to be done, and the government's not going to reform the judicial system without a serious fight, I'll tell you that. So if you go to Soffer versus Chase, click on the first link, you'll see the documents I'm talking about, and if you also go onto the website for SD Court, switch the case status to 2015 13627, you'll see the other case I'm involved in that proves the crimes the police and the DA have committed. Please watch Part 3 of Tyranny, Soffer versus Chase. Thank you.